Okay, I think now's probably a good time to start. So first of all, just wanted to welcome everyone to tonight's event, which is a seminar being put on by the Garden Court housing team. We'll be discussing how to represent homeless applicants who have been found to be intentionally homeless. I'll begin with some speaker bios and then some announcements. So first, we've got two speakers tonight. First speaker will be Georgie Ray. She has a detailed knowledge of possession proceedings. She regularly conducts work across all areas of housing law, including possession, disrepair, and homelessness. Our second speaker tonight will be Edward Fitzpatrick. He's a specialist housing barrister with a particular interest in homelessness appeals, public law challenges, and cases involving human rights and Equality Act issues. He's ranked for social housing in both the Legal 500 2023 in Tier 1 and in the Chamber's UK Bar Guide. So before I pass over to them, just a few announcements. Firstly, this webinar is being recorded. We'll send out the slides and recording link to everyone who's registered to attend. Please put any questions in the Q&A box, and once the speaker's finished, we'll aim to answer your questions at the end of the webinar, time permitting. We aim to finish tonight's event at 6:30. I've also been asked to announce several webinars which we have coming up later this month, with another housing one on 18th July. And those forthcoming events are, on the 17th of July, we'll be having a seminar on victims of trafficking, challenging public order disqualifications and NRM delay. On 18th of July, in particular interest to housing practitioners, we'll be running a seminar on the Renters Reform Bill. Also on 18th July, we have a seminar on judicial review and mediation. Do they go together? And on 25th of July, the need for lawful notice prior to eviction of travellers, ESSO and Thanet, an important case study. So without any further ado, I'll pass you over to Georgie Ray, who'll be our first speaker tonight.
Thank you so much, David. I'm just going to share the right screen. And here we go. So today I'm going to be talking about intentional homelessness, specifically deliberate acts, causation and affordability. So the three questions I want to address, firstly, I'll be looking at what amounts to a deliberate act, particularly where mental health is concerned. Secondly, what is the correct test or approach to causation? And finally, how to approach affordability cases where applicants lose property due to rent arrears. And I've got a cost of living update for you there that we think would be really useful in the current cost of living crisis. Just a quick note that this slide will be focusing on English law. The context in Wales is slightly different, so it's important to highlight that, although much of the case law does remain the same. So what is the relevance of this concept of intentional homelessness? It has reduced in relevance over time, and the current position is that an applicant who is homeless but is not found to have become homeless intentionally and who has a priority need, if they're still homeless at the end of the section 189B duty, they'll generally be owed the main housing duty under section 193. The position is different, however, if they're found to be intentionally homeless, even if they are priority need. So the main housing duty will only apply where the local housing authority is not satisfied that the applicant became homeless intentionally. So they need to, if they're going to apply that exception, the housing authority would need to satisfy themselves of intentionality. So firstly, then we're going to be looking at deliberate acts. So under section 191 of the Housing Act, we get the definition of becoming intentionally homeless, and a person becomes intentionally homeless if they deliberately do or fail to do anything in consequence of which they cease to occupy accommodation which is available for their occupation and which it would have been reasonable to continue to occupy. So that's got quite a long sentence, and we can break it down, and it's broken down into this 6-part test, and every part of the test needs to be met before a finding of intentional homelessness can be made. So that there are lots of inquiries that local authorities will need to make. So the first question is, was there a deliberate act or omission? And Ed's going to be looking more at the good faith exception. Secondly, was it an act or omission by the applicant? So not someone in their household, for example. Number 3, was it in consequence of that deliberate act or omission that they ceased to occupy the accommodation? 4, is the deliberate act or omission and the cessation of occupation it caused an operative cause of the present homelessness? I'm going to be looking at that in more detail. And then, would it be reasonable for them to have stayed in the property and continue to occupy the accommodation? So I'll be looking at affordability in the context of that reasonableness part of the test. Great. So we've got some examples of what will generally not be a deliberate act, and they come from the Homelessness Code of Guidance for Local Authorities, published in 2018. So the applicant needs to be given an opportunity to explain their behaviour. And as I said, Ed's going to be looking at this good faith exception to a deliberate act. So where it will generally not be considered deliberate, for example, non-payment of rent or mortgages, where the financial difficulties are beyond the applicant's control. I'll look at more at affordability later. B, this often comes up in the context of disabled applicants, so where the housing authority has reason to believe that the applicant is incapable of managing their affairs, for example, by reason of age, mental illness or disability. If the act or omission was a result of their limited mental capacity or illness, frailty and substance misuse, and so sometimes that will come into play in antisocial behaviour evictions, for example. We've got exceptions where the action was under duress, so that expressly won't be a deliberate act. And as I said, the good faith exception, which Ed is going to look at more. So that's what won't be a deliberate act, but what will be a deliberate act? Oh, no, I'm going back. Oh, so no, sorry, still 2 more noteworthy not deliberate acts. So yeah, the non-payment of rent or mortgage arrears if there's significant financial difficulties, and housing authorities should be alert to the impact of economic abuse, control and coercion in the domestic context as forms of domestic abuse. And the reasons why arrears accrued should be fully explored, including examining the applicant's ability to pay the housing costs at the time the commitment was taken on, and if anything has changed since then. So now we'll look at the examples of acts which generally will be deliberate. So someone choosing to sell their home where they were under no risk of losing it, willful persistent failure to pay rent, eviction because of antisocial behaviour. But as I said, we need to scrutinise more carefully whether or not that antisocial behaviour arose in consequence of a disability, threats of violence, and then tied accommodation where you leave a job and your accommodation is tied to that. So those are some general examples found in the Homeless Code of Guidance, and it's important to be mindful through all of them of the particularities of the applicant's circumstances. So next we're moving on to causation, because as we saw at the start of my slides, the deliberate act needs to have caused the cessation of occupation. So we get this test from the case of Harley. I've got the full citation there, and 2 separate questions arise concerning causation. So firstly, the question is, did the applicant become intentionally homeless? by failing to do anything, so by the deliberate act in consequence of which they cease to occupy the accommodation. And then secondly, we look at whether the current homelessness is caused by that deliberate act, or whether there have been intervening events that have kind of broken that chain of causation. So has there been a cessation of occupation at all? Well, that depends if there was occupation in the first place. So it's a broad definition of accommodation that can be considered by local housing authorities. So it could have been accommodation that was being occupied overseas, but merely failing to take up an offer of accommodation that you weren't already in occupation of will not be enough to demonstrate cessation of occupation. So decisions of applicants to rid themselves of accommodation that they haven't occupied, for example, a second home, or not to accept accommodation offered to them, can't result in findings that they have become intentionally homeless. And then we need the causal link. And there's a nuanced way that the courts approach this, and it was set out in Harley, but it comes from this previous case law. So you have to identify the real or effective cause of the homelessness, and that should be approached in a practical, common sense way. And whether a number of independent factors separately contributing to the loss of accommodation, so that will be parallel causation, it suffices if only one of them was a deliberate act or omission of the applicant. So even if there are a mix of factors that led to the cessation, if only one of them is the deliberate act of the applicant, then that will be enough to establish causation. Where a sequence of connected events led to the cessation of occupation, the question is whether it was reasonably likely that the act or omission would have resulted in homelessness. So if they do something that leads to another thing, was it reasonably foreseeable that that would result in homelessness at the end of the chain? And finally, the chain will be broken by an intervening independent act or omission of a third party. And that part of the test looks very similar to what we're going to move on to, which is that the deliberate act needs to be the cause of the current homelessness. So the chain here can be broken if, for example, someone became homeless and then spent time in settled accommodation, that will break the chain. And if they become homeless again afterwards, it's not because of the original homelessness that was caused by a deliberate act. So what amounts to time in settled accommodation? I've got the case law of DOCA here from 2017. Settled accommodation won't include, for example, time spent in holiday lets or statutory overcrowded and unaffordable assured short hold tenancies and bare licenses, for example. But something that will break the chain of causation, it could include long-term occupation of the parental home, a freehold or a leasehold, or indefinite license or permission to occupy. So that kind of starts from scratch. And if there ever was a deliberate act in the past that caused homelessness, the period of time you've spent in this new accommodation will break that chain of causation. Other examples of things that will break a chain of causation that isn't time in settled accommodation. There I've got two examples. So the first is a couple moved into stay with their family for a while after selling their property, but then their marriage broke down, and it was found that the breakdown of the marriage was an intervening act, and that so the chain of causation was there broken. And again, spousal desertion following a move is also enough to break the chain of causation. And we can see the logic behind that because it's things that were out of your control and that aren't related to the initial decision or deliberate act. Okay, moving on to affordability. So this is relevant to the question 6 as I set them out. in the initial slides. So would it be reasonable for the applicant to have continued to occupy the accommodation? So under section 210 of the Housing Act, the Secretary of State made the Homelessness Suitability of Accommodation Order in 1996. And that specifies that in determining whether it would be or would have been reasonable for a person to occupy accommodation, they have to take account of whether the accommodation is affordable. And it sets out some particular examples of things that must be taken into account in assessing affordability. And those are repeated in the Homelessness Code of Guidance at paragraph 17.4.6. So things that need to be taken into account include financial resources available to the applicant, savings and other capital sums, which may be source of income or might be available to them to meet accommodation. So we can see this as a broad approach to affordability. So all types of savings and, for example, child maintenance or child benefits will be considered as income that could have been put towards accommodation. Then they'll balance that against costs in respect of the accommodation. So their outgoing payments, the necessities of life, and other payments which the person is required to make, for example, under a court order, and then only then other reasonable living expenses. So what amounts to a reasonable living expense? The ordinary necessities of life. And I'm going to resist singing the Jungle Book, but accommodation is not reasonable for an applicant to continue to occupy if the cost of paying for it would deprive the applicant of the means to provide for the ordinary necessities of life. But what constitutes that is a question of fact, and it can vary according to each applicant's needs and the needs of their household. So the local authority needs to take careful consideration of those circumstances. And if the local authority just broadly asserts that an applicant can make savings and that the accommodation is affordable if they were to cut down their spending without considering, well, what do you say as the local authority, what do you say they're spending too much money on? That decision won't be lawful unless there's something clearly identifiable that that is exaggerating their expenditure. The guidance in the code is relevant, and the English code, so that's the Homelessness Code of Guidance, advises that housing authorities need to consider whether the applicant can afford the housing costs without being deprived of basic essentials such as food, clothing, heating, transport, and other essentials specific to their circumstances. But we're all acutely aware at the moment that a lot of those items have increased significantly during the cost of living crisis, and basic essentials are now bankrupting people, essentially. I'm going to look at this particularly, well, slightly unhelpful, but hopefully we'll get around it, case of the Royal Borough of Kensington upon Thames and Bapty, and that was decided by the Court of Appeal in 2022. So affordability, the court found that affordability of particular accommodation for an applicant was not a question of whether their actual residual income after living expenses was enough to meet their rent obligations. And the local authority had to determine whether the rent was one that the applicant could reasonably afford. And whilst that depended on their available income and reasonable living expenses, the reasonable living costs of an individual or household were the sum they reasonably needed to provide the necessities of life to a minimum standard. So really that is looking at the absolute bare minimum, and anything over that, local authorities can consider should be put towards income, and they can find that the accommodation is affordable. The Association of Housing Advisors Service published a document, so it was evidence-based for costs of living and guidance for caseworkers. And in the case of Bapty, the local authority had relied on that to kind of show what that bare minimum base rate of living looked like in the area, and the court found that it was reasonable to rely on that index, and in that, yes, the guidance was reliable and objective, and there was no reason why the reviewing officer was doing anything wrong in placing significance on it in their assessment of homelessness. But that was 2022, and we're in 2023 now, and the cost of living crisis has only augmented. So that same Association of Housing Advice Services has updated their affordability report. So the May 2023 version does take into account the significant increases in the cost of living, including food inflation and heating. What's interesting is the slide on their website. They have made public the slides that were presented to the Council of Westminster at the Association of Housing Service seminar. And these slides are from just after the judgment in Batty. And in those slides, it says that the starting point for assessing affordability is still the case of Samuels. So that was decided in 2019, and that is a much more favourable view of affordability, and doesn't look at that bare minimum threshold. So that will still be the starting point. Universal credit is the minimum income for a household and the starting point for the assessment. The local authority can then assess the reasonable living expenses, and if those expenses are more than universal credit, then although it doesn't automatically lead to the conclusion that the accommodation is unreasonable to occupy, it will be a good indicator, especially if the expenses have increased due to the cost of living crisis. One thing that they might look at, that local authorities might look at, however, is whether or not some of those cost of living increases are merely temporary. So if we were spending more on fuel during the winter, is that likely to reduce during the summer? And so if your applicant is approaching the local authority in the summer, would they find that the accommodation was affordable and therefore it was reasonable to continue to occupy it? And we can see there that another thing they will take into account is the forms of relief from the government. And although those, obviously they are costs those are sums very specifically meant to tackle very specific household outgoings, such as heating, in these local authority assessments, they might look at those as sources of income that could be put towards rent. So even if you're getting a tax credit, the accommodation will be affordable because rather than using that to heat your house, you could be using it to pay for your accommodation. So it's a bleak economic picture at the moment anyway, but hopefully by going through, by putting the burden on the local authority having to establish all 6 of those elements, there are enough barriers to demonstrating that an applicant is intentionally homeless, that if they found themselves in the position at the end of the housing duty, they would still be entitled to relief. And with that, I'm going to pass back to Ed. Oh no, well, David first probably, and then
Thanks, Georgie. And before I do call Ed back, can I just thank Georgie for that talk and for covering a very wide range of subjects which come up regularly under intentional homelessness, and giving us a wonderfully clear structure to see how the whole of this concept fits together. Before I pass over to Ed, just one last thing, which is to remind people that at the end of the 2 presentations today, we'll be taking questions through the question and answer box. We've already had a few questions come in through there, so many thanks for them. But anyway, I'll pass you over now to Ed.
Right, I think everyone can hear me now, hopefully, and you got my notes on screen. That's the hardest part of my day. I was interested just in what Georgie was saying about one of the cases that come up a lot are intervening accommodation. If you've got the mark of key and you've been found intentionally homeless, what type of accommodation, if you've got an assured short-hold tenancy, can be intervening. One of the cases where I think the boldest arguments raised on this was a case, I think it was called Jones, where it was argued before the Court of Appeal that a period in custody amounted to settled accommodation, so that when the person was released from custody, they could no longer refer to the accommodation they'd stayed in before they got sent to prison. That was a very bold argument run. I won't say who it was that ran that argument, but some of you may know. So what I'm going to talk about is a couple of discrete topics on homelessness. And the first topic is repeat applications, because it does arise a lot where someone's been found to be intentionally homeless, and your circumstances change. To what extent do they change in order for you to be able to make a further application? And the starting point being the legislation, which doesn't bar, there's no limitation set on how many applications you can make. And we all know that people can actually make more than one application at the same time. So in terms of the case law on that, previously, we had cases such as Campisi, which said that if the local authority have discharged the duty to you, or find you intentionally homeless, etc., that they're only obliged to accept an application if there'd been a material change in circumstances. And that was rejected, although it wasn't directly on the same type of facts in the case of Fahia before the House of Lords. And in that case, the applicant and her 6 children had been evicted from private rented accommodation and found to be intentionally homeless. While their case was being considered, for a long time they were staying in a guest house, and they continued to stay in the guest house after their case had been decided and it was found that they were intentionally homeless and no duty arose. But eventually there was an issue over the housing benefit payments for the guest house, and they went back, made a further application. And the issue really was before the House of Lords was whether or not the further inquiries had to be made at all into the case. And what the House of Lords found was that it could not be said that there was no relevant change in circumstances and since the previous application, and that the 2 applications couldn't be treated as identical. And that was based on their consideration of just the wording of the statute, really. So that decision then fed into the case most of us will know about and familiar with, Rika Begum, in the Court of Appeal, where it was directed precisely at the issue of a second homelessness application following an unsuccessful previous one. In that case, the appellant had refused an offer of permanent accommodation, basis it wasn't suitable, unsuccessful appeal to the county court. She then went back to live with her parents, and there was some changes in circumstances. I think she had another child along the way. But sometime after, she made a second homelessness application on the basis it wasn't reasonable for her to continue to occupy her parents' address. And the local authority said, well, your situation hasn't changed since your previous application, so go away. And then we get, in the Court of Appeal, another seminal judgment from Lord Justice Neuberger, as he then was. And if he finds that where a person applies for assistance, previously made an application, they have to accept the application unless it's on exactly the same facts as the previous application. And the wording is exactly the same facts as the previous application. And what was said, and I've quoted from it, he went on to say that where a person makes a subsequent application, it's their responsibility to identify the facts which render it different from those at the date of the determination of the previous one. So if someone refuses an offer of permanent accommodation, duties discharged, they're in temporary accommodation, they're going to be evicted from that because they've refusal of the offer under section 193. If there's been no change, then the local authority are entitled to say, this is identical facts, go away. And they're also entitled, without further investigation, if there's no new facts or it's fanciful, to reject the application. But he goes on to say, however, if the new facts are not within the authority's knowledge and are not in the light of the information available, fanciful or trivial, they must accept the application. It is not open to the authority to investigate the accuracy of the new facts before deciding to accept a subsequent application. So that involves an extremely low threshold, which is clearly helpful to applicants. Now, an issue arose in a case I dealt with, the case of Ibrahim in Westminster City Council. And the question raised there was really whether or not new facts presented have to come into existence after the previous decision. So you've got one decision. Is it the case that in order to go back, you must identify new facts that have arisen since that date? And this was a very difficult case on the facts. And I will go into some detail because it's quite important in terms of the way the case was dealt with initially and then by the local authority. The claimant had been a national of Congo, and as is set out, she was married to a general who was married to a general who was I think he was, I'm misquoted that, he was working for a general in Congo and he was murdered. She was raped and threats to kill her. She arrived in the UK and claimed asylum, provided with temporary accommodation by NAS in Middlesbrough. And when her asylum application was accepted, she was provided with accommodation in Middlesbrough in private rented accommodation. And then in July 2017, a male occupant of the neighbouring flat came through a bedroom window while she was in the bath. He was arrested, subsequently released. Not surprisingly, she fled from that situation. She came to London and she stayed with friends. And at that point, she started to receive treatment from a psychiatrist, Dr. Kettley. And eventually she could no longer stay with the friends. So she made a homelessness application. And on that, in fact, she made a first homelessness application. And in terms of that, there was letters from the psychiatrist, which were raising issues to do with the incident that happened in Middlesbrough, triggering her previous post-traumatic stress disorder and her trauma. However, on the first, and then indeed on the second application, the local authority, Westminster, considered the case from the perspective, two perspectives really. Firstly, whether or not there was an ongoing threat of violence from this neighbour. And effectively, they contacted the police and said, well, we don't think there's an ongoing threat. It's a one-off incident, etc. And then secondly, they, particularly on the second application, they considered the question of whether or not she lacked capacity when she left Middlesbrough and fled to London. And on the second homelessness application, as I've set out, there was a third report from Dr. Kettley, which was dated the 11th of February 2020, and it set out that it is obvious she could not have remained in the property in Middlesbrough. The option the only option available to her was effectively to leave. That reports, and there was evidence that it was submitted to the local authority, but it didn't come to the attention of the reviewing officer for whatever reason. It was lost or whatever. They came up with the review decision a few months after, on the 28th of August 2020. Solicitors had been representing her to an extent on that second review, but they didn't even put in any representations in. So she was in a situation where the second review found that she was intentionally homeless, as with the first review. The position was instructed new solicitors, Osborne's, and they made representations. And the first thing they argued was that, well, this is a terrible review decision. You haven't taken into account the third report. We want you to agree to allow an appeal out of time. And as we know, there's a very limited discretion. Well, there's a discretion for that to take place, but a challenge on that is extremely difficult. And that was assessed, and it was determined that we couldn't challenge that. The second thing they looked at is arguments to say that they ought to withdraw the review decision. And again, the authorities on that topic are very difficult. The third thing was a challenge decided to do was to make a further homelessness application, despite the fact there'd been two previous ones, arguing that facts weren't identical to those considered on the basis that Dr. Ketley's report hadn't been considered. And it was also argued, or the main plank of the argument was that throughout the previous two homelessness applications, there was a failure on the part of the local authority to consider whether it was reasonable for the claimant to continue to occupy the accommodation in Middlesbrough. They hadn't properly addressed that in the previous two decisions. It was argued that the whole approach was flawed, and that effectively should have been front and centre to the consideration of this case in the light of these psychiatric reports. The local authority argued that the material relied on was not new and had come into existence after the previous review decision. There was a very helpful decision by Mr. Justice Sewell, which wasn't appealed. He relied on a case of Hote, which set out that the fact that material is before a decision maker does not necessarily mean that the facts have been accepted to be the facts actually existing at the time the decision was made. And he used that as a platform for reaching a decision that he didn't accept that a new application is dependent on the occurrence of a fact or circumstances which postdates the original decision. And he held that I can see neither authority or reason to exclude a relevant new fact or circumstance since the original decision, not least as here, where the relevant material has been supplied to the authority, but by some error, it has not been placed before the reviewing officer. He rejected arguments of public policy to say that this opens the door for repeat applications arguing that previous decisions weren't properly formulated, etc. He also rejected an argument that was put that to say that effectively it's not our fault, it's down to the fact that the previous advisors didn't raise this issue. On that, he found that this was an obvious point, the reasonable to continue to occupy was an obvious point for the authority to consider as part of its duty of inquiries, notwithstanding the point was missed by the claimant representatives. And there was also an argument to say that there was some reference in the review decision to reasonable to continue to occupy in passing. And he said even on the benevolent interpretation, it couldn't say that that was properly considered. So in terms of the test for intervening, he said it was conventional judicial review, and his judgment was that it's clear that no reasonable authority could have concluded that this was not a new application. Also, in deciding the case, he found that there was a complete flaw in the earlier decision making with regard to the Equality Act. And in particular, the fact that one had, even without the last psychiatric report, one had two psychiatric reports that pointed to the re-triggering of the claimant's trauma due to this event. And he found that there was a complete absence of the necessary sharp focus. So in terms of it, that case, it's helpful in respect of where, firstly, there's evidence that wasn't considered that should have been considered, but also if there's a completely flawed approach taken by the local authority on a previous decision, I think that is a platform for arguing that a further application should be entertained by the local authority. I mean, it was interesting in that case that they, after they were forced to accept a new application, they then came up with a section 184 to say that the claimant made herself intentionally homeless. And then that went to review, and it was only at the review stage, the reviewing officer, I think, read the judgment and went, this can't possibly stand, given these psychiatric reports. So thankfully, they backed down. In terms of the application, I've got one case on the go where there was a previous decision finding that a discharge of duty, and it was on the basis that our client had refused to accept accommodation offered that was suitable. And since that event has been in temporary accommodation, has now been evicted. But in terms of the situation, the medical evidence makes it very, very plain that he lacked the wherewithal to actually engage and to sign up for a tenancy or to process whether or not it was a suitable offer without support and assistance due to his ongoing mental health issues. And there's reports around the time that the offer was being made that don't feature properly in the review decision. And there's no reference to the Equality Act at all. So I think it is helpful, the approach taken in Ibrahim moving forward with further applications, repeat applications, and challenging previous, in certain circumstances, previous decisions. So the other main topic I was going to address is the section 191 subsection 2, and we'll always have to go back to the wording, because the wording is that in terms of subsection 1, it's a person becomes homeless if he deliberately does something. So subsection 2 is about, for the purposes of subsection 1, an act or omission in good faith on the part of a person who is unaware of a relevant fact shall not be treated as deliberate. So you've done the act, but these are the circumstances where it's not to be treated as deliberate. And I mean, in terms of intentionality, I always quote from the Supreme Court, Lord Reid in Halley v. Waltham Forest, which is to do with completely different set of circumstances to do with whether or not there'd been intervening event that made a person who'd been evicted from a hostel could no longer be relied on. But one of the observations by Lord Reid was that the whole purpose of the provisions under 191 is to prevent queue jumping. And I mean, I have to say, there's very few cases where it can sensibly be said that our clients have been involved in queue jumping as such, in terms of their conduct. But in dealing with the section 191 subsection 2, I mean, there's been a plethora of case law, and actually some very interesting cases on the facts have arisen, but it's worth looking at the way in which the approach is developed, because there's two aspects to it. Firstly, whether or not someone was unaware of a relevant fact, and whether or not someone acted in good faith. And I think it's fair to say that recently the higher courts have focused more on whether they were unaware of a relevant fact. And there's quite a restrictive approach being adopted, whereas in terms of good faith, the authorities are, I would certainly argue, more benevolent. But the starting point goes back to a case of Obeid, where Carnwath J, and it's a case that's been followed by the Court of Appeal throughout, where he dealt with a situation, again, the facts were not uncommon, where someone had made a homelessness application and they were going to be offered accommodation, but they found their own private rented accommodation, and they thought, well, that's a nicer property in the area we want to live. So they signed up for that. But they then found out that the rent was £200, but quite a while ago, but the rent was £200, but the maximum housing benefit was 180. But In that case, it was found, and the future event there was whether or not they were going to be able to move to this other accommodation and pay the rent. And the seminal part of the judgment I've put in bold: an application's appreciation of future housing or future employment can be treated as awareness of a relevant fact for the purposes, provided it is sufficiently specific, and then provided it is based on some genuine investigation. And I'd highlight the adverb some. So it's some, it's not full, it's not comprehensive, it's some. So that was obeyed. Then there's lots of other examples of whether or not someone's unaware of a relevant fact. These are the cases that are cited all the time. A.W. Aiden was a case where the applicant gave up accommodation in Belgium to come to the UK, but with no definite plan, no job to come to. So there was nothing, didn't get interviewed or anything. And that was where it was found that there wasn't any relevant fact he was unaware of. He was resting on little more than a wing and a prayer. Then there was another case, F in Birmingham, where again, that was a case where they applied for accommodation, and it was clear, it's said to be clear, that they wouldn't be able to afford this accommodation, and it was held that they closed their eyes to the obvious. So it was found that there was no relevant fact they could latch on to, and good faith didn't arise. Najim was a case where it was held that a relevant fact of which an applicant is unaware must exist at the time of the deliberate act or omission. So normally the deliberate act or omission is giving up accommodation, whether it's in this country, lots of people move for a job, or coming to the UK on the basis of prospects of a job or accommodation. So it's at that point, and you've got to, if the relevant fact doesn't exist, you can't get off the ground. Then there was a case, Dorman Dingar, where it was said the relevant fact must be relevant to the extent that had the applicant been aware of it, it would have been taken into account in deciding to whether to give up their accommodation. And I mean, that's fairly obvious. If it's not relevant at all, then it's not something that really ought to be taken into account. The case of Lucy is interesting, and in that case, it involved a couple who moved to Turkey for a business opportunity, which was in fact to they were setting up a factory to sell dog and cat food, and they went there. The business opportunity proved to be unsuccessful, and they returned to England and applied as homeless, and it was on the basis that the mistaken belief they were pursuing a sound business overseas, and it was found that was capable of amounting to a relevant fact. Then there was the case of Beattie, which sets out that ignorance of legal consequences of a deliberate act is not sufficient, and it's also been found that lack of knowledge as to legal consequences. I didn't know that if I did something in my flat, I'd be evicted. I didn't know that if I had a row with my neighbor or blah, blah, then lack of knowledge as to the legal consequences is not going to amount to a relevant fact. Although one of the cases we come on to, Ugabi, that the fact that someone there effectively was unaware of their rights in terms of an assured short-hold tenancy, and they didn't get advice, but it was accepted by the local authority, that could amount to unawareness of a relevant fact, their unawareness of the eviction process that the landlord would have had to go through. But then we come on to a case which I would certainly detect what appears to be a hardening of the approach on unawareness of a relevant fact. It was a case of Alfonso and de Trindade and Hackney. Now, in that case, they seem to have lost the adverb some genuine investigation, and it's genuine investigation. But there, the approach is quite restrictive. And again, it's worth looking at the facts to a degree, because the applicant there lived in Sao Tome, which is an island off West Africa, came to the UK primarily because her daughter needed medical treatment, and what was sought was assistance with medical treatment. But before coming to the UK, there was a plan. She was going to stay with her sister. Sister had accommodation, could accommodate her. It wasn't going to cause a problem with the landlord. And she had duly arrived in February 2013. But in August 2013, the landlord, out of the blue, decided he wanted to refurbish the flat and get rid of the tenants. So you would have thought that she's got this, some genuine investigation. She's got somewhere to stay, so she's a bit of genuine investigation. But what's interesting about the case is that the findings of fact made by the reviewing officer were very precise, and they involve detailed consideration of the evidence put forward. And what was found was that she had no understanding of how long she could stay with her sister. It was a temporary arrangement, and she'd no idea, as it were, what she was going to do after that came to an end. And the reviewing officer said that she'd sown the seeds for her homelessness in making this kind of reckless move. And the Court of Appeal effectively agreed with that approach. And the leading judgment is from Lord Justice Sales, and again at paragraph 26, I've set it out there, and it's, in terms of it, as I say, what one's got, that you've got to have an active belief that a specific state of affairs would arise or continue in the future based on genuine investigation about those prospects. And later on, he refers to a situation where the good prospects don't materialize. So that is a tough approach, and he differentiates between some genuine investigation, no investigation, and where people can be said to be acting on a wing and a prayer. So what we find is that yes, the focus in a lot of decisions is on whether someone's been unaware of a relevant fact, and the test to be deployed is at paragraph 26 in Alfonso. In a case I'll refer to, SIFT-C, that was the approach that was adopted again by the Court of Appeal. The other aspect is good faith, which doesn't cause such a problem. And there's obviously an interplay between the two, but the test going back to Lucy is quite helpful. Honest blundering and carelessness, the court saying there's no reasonable requirement. So if you're an honest blunderer, going back to Canworth, he said, well, if you were someone who chose to investigate the whole situation, you might be in trouble because you'd find out that it's a bad plan. But if you're a bit of an honest blunderer, you'd be okay. In O'Connor, there's reference to a situation where Lord Justice Sedley finds that the statutory dividing line comes at the point where the applicant's ignorance of relevant fact was due to his own unreasonable conduct at the point, and by shutting his eyes to the obvious. Then there's the case of Ugabi, which I referred to earlier, where again, Lord Justice Lloyd talks about the conduct not amounting to willful blindness, and sets out that the use of the phrase good faith carries with it some kind of impropriety, an element of misuse or abuse of the legislation aimed at protecting local authorities. Now, one does wonder, because it wasn't key to the ratio in Alfonso, but it was also found that the reckless behaviour wasn't in good faith, coming to the country to seek medical treatment. But under the approach in Ugabi, it's not conduct that's in any way improper. So on good faith, as I say, you've still got those authorities here like Ugabi. Another issue that arises is very often people aren't represented at the review stage, as we all know. But what is the duty on the local authority? And in terms of that, you've obviously got the duty of inquiry is on the local authority under Section 184. Section 191 apply. The local authority's got to apply it. It's got to go through it. It's got to consider each aspect of it. In the case of F and Birmingham City Council, the Lord Justice May found that in conducting a review, that the local authority is obliged to look at Section 191, even if it's not been specifically, I can't see it because it's blocked out, but referred to, if it's sensibly capable of arising on the facts. So sensibly capable of arising on the facts, that again is quite a low threshold. So do you expect that the reviewing officer in many of these cases would have to address it? But there was a case before the Court of Appeal, which I dealt with, SIFC, and again, on the facts, quite a case where I would say that one ought to have some sympathy for the applicant. She lived in France in Switzerland with her son, disabled with prosthetic legs, and she was suffering harassment at work. So eventually, and she was also having mental health issues at the time, she gave up her secure property in Switzerland and she moved to the UK. And this was all done through her sister, who identified temporary accommodation that she could stay at, and also a job that she could go to with Rainbow Meats. But it was a job that ostensibly that she would be able to do with her disability because it wasn't a physical job. She arrived over, she was in the temporary accommodation, but after a few months, she found there was too much standing around that had to be done for the job. So she had to leave the job. Her temporary accommodation fell apart and she wasn't able to secure other accommodation because she wasn't working. So she made a homelessness application, and the Court of Appeal considered the main issue raised in the case was to do with the level of inquiry and the fact that the reviewing officer didn't look in any detail at all, or didn't address the issues under Section 1912. The reviewing officer was effectively fixated with saying that she hadn't got a proper plan and that she didn't have any settled accommodation to go to, which is the wrong test. But in terms of the approach to be taken, as I say, Lord Justice Lewison he gave the leading judgment, and he found that in terms of Section 1912, there is no such duty outside the circumstances of obviousness, or where the local authority have been put on warning that something may arise. And so again, that is quite an unhelpful approach to take in a situation where someone's not represented and they don't know what Section 191 subsection 2, the protection that can be afforded to it. In addition, it was found that whilst the reviewing officer had not explicitly considered whether the applicant fell within Section 191, the inquiries made by the reviewing officer were sufficient. The court also rejected the fact that this reference to settled accommodation, etc., didn't make any difference, and found that there was references to acting on a wing and a prayer without going into the detail of what is required under Section 191 subsection 2. And another point that is worth noting for any application is that it was said that it was also found that the applicant never made a proper link between the job and the prospect of future accommodation. And essentially what the court says is that in terms of a job, you've got to link that to the homelessness situation. So you've got to be able to say that my case is that I've got a good job lined up, maybe temporary accommodation or even staying in a hotel or a hostel, but this job would have secured my future in terms of housing, so I wouldn't have made a homelessness application. And it was found by the Court of Appeal that that link wasn't made, so effectively considerations about the job were secondary, and then her actual temporary accommodation that she went to was effectively precarious. So, as I've set out, in terms of future prospects of employment, which was result in housing and future accommodation, I think the recent cases would suggest that the approach in terms of relevant facts is a bit less benevolent than it was. I find it very difficult to see how someone acting in person is going to be able to make submissions on a review or at first instance demonstrating that they had an active belief that a specific state of affairs would arise or continue in the future based on a genuine investigation about these prospects and not mere aspiration, and show that the apparent good prospects didn't work out. I mean, that is completely unrealistic. But as I say, the Court of Appeal have taken a fairly restrictive approach. So what we can derive from all that is that it's really important on a review, to address head on the two key requirements of good faith, which is easier, and a relevant fact in the light of these authorities. And effectively, you've got to address what was the genuine investigation or some genuine investigation that took place before the act that resulted in the homelessness came about. Finally, a more positive decision is an interesting decision in the case of Poshte, which people might remember went all the way to the Supreme Court on suitability. And it was a case where it was a challenge as to suitability of accommodation offered, which eventually failed. But the interesting thing about it was that there was a further application, and it's reported in legal action last year, but it was to say that when the accommodation had been offered, the applicant was unaware that they could accept the offer and at the same time to apply for a review. And His Honour Judge Roberts allowed the appeal, holding that the decision to say otherwise was irrational on the facts, and that no rational reviewing officer could have reached such a conclusion. And accordingly, the decision was varied to say that she wasn't intentionally homeless. And that's a very long road travelled by Ms. Poshte. Thank you.
Well, thanks to Ed. I think at this point we'd be normally expressing our gratitude to the speakers in the usual fashion, but certainly I thought that was a wonderfully wide-ranging paper, which did a brilliant job of bringing out the facts behind the cases which so many of us have been reading. I'm now going to open it up for questions. I've got half a dozen already in the Q&A thing, so I'm going to take them and I'll try and allocate them to the speaker that thinks that's right. But if I make a suggestion and actually another person, either the other speaker wants to speak to it, that's fine, of course. So just starting, the first question I see, this is quite a specific one, is asked by Abdurrahman Sufi, who says, and I'm going to give this to Georgie in the first instance, he asks, would settled accommodation also include accommodation provided or extended on a discretionary basis during the pandemic?
Thanks for this question, Sufi. So I'm sure the slides will be shared with you, but the problem is with settled accommodation, the court really is looking at some sense of stability and a definite period. So anything that was given on the proviso that this is only temporary, it is unlikely to be viewed as settled accommodation, but I would definitely look at the kind of agreement that that accommodation was offered under, to see if there's any way around that.
Yeah, I mean, I agree with that, but I mean that is the problem, that if it's in any way precarious, then it's not going to be categorized as settled. But sometimes you have situations where people are put in temporary accommodation and they're forgotten about and they live there for a long time, and then you can argue as a matter of fact and degree that they at some point in time it's become settled accommodation. But I think it's very difficult to argue accommodation provided during a pandemic is settled. That's a tough one.
Thanks both. Now, the next question I've got, I'm going to give this to Ed in the first instance. It's from Rachel Lovell, and it goes as follows. To what extent can we require the local authority to look behind a criminal conviction which led to the loss of the last settled home due to imprisonment in circumstances where there is now medical evidence to support a finding that the client lacked mental capacity at the time of the event for which they are prosecuted? The criminal event was many years ago and the client did not appeal.
I mean, I don't know if this is a situation where you're trying to reopen a previous decision, make a new application, or a situation where the person's been in temporary accommodation ever since. If it's the latter, yeah, I mean, if it's the latter, I think that in circumstances where, I mean, it goes back to what Georgie's saying about the chain of causation, the domino effect. So you committed an offence, you go to prison, you lose your accommodation, etc. But if you can prove that you lack capacity at the time of the offending, I would argue certainly that it was not a deliberate act. And if it's the latter, where this happened a long time ago and things that happened in between, I suppose you'd have to look at whether or not the person's been in other settled accommodation in the interim and been evicted from that or whatever. But yeah, certainly I think more and more with the application of the Equality Act, we do have the ability to scrutinize these decisions. I mean, it used to be that the courts would just say, well, unless it's, mental aberration, that, it has to be incredibly extreme. I think these days, with the Equality Act and the sort of assessments that have to be carried out, I think you've got much, more chance of raising valid arguments.
Yeah, I'd agree with Ed. Just 2 points that I wanted to raise. So, I mean, if we look at the purpose of intentional homelessness as a concept, it's to stop, well, from the local authority's point of view, it's to stop people benefiting from their own deliberate actions or things that were their fault. But it's really clear, and it has been clear since like the start of these interpretations. So particularly if we look at the Court of Appeal, very old case, the Hawthorne case, it's not the purpose of the Act to deprive someone of assistance if what's happened to them isn't their fault, and it has come about because of disability, lack of capacity, and inability to care for themselves. So if you've got the evidence about the initial conviction, it should definitely be raised. But the second point, obviously, whilst settled accommodation is one thing that might break the chain of causation, if there's been any other intervening events, anything that happened in prison, if there was a sectioning at any point in prison as well, those might amount to intervening events, even if there hasn't been settled accommodation. So it isn't just a settled accommodation question.
Okay, thanks both. Now, the next question I've got, and by the way, can I just apologise to anyone who's listening? It's probably very strange. You're probably seeing my finger going into your screen. I'm accessing this during an iPhone, so my apologies if that's just strange for everyone who's involved in this seminar, but that's where we are, unfortunately.
Although you're a strange man, David.
Oh, thanks, Ed. The next question I've got, and again, if either of you want to come in on this, because it's quite unusual, and it's something as barristers we don't necessarily get that involved in, is the one I see Georgie's typing an answer, but I'll actually read it out, Georgie. So if you can give this answer orally, that might be better, because then everyone can see it. The question is, I've recently had an ombudsman challenge, and cited that the centre minded to intentional decision too early, This was sent following initial inquiries upon speaking to both the landlord applicant and completing the affordability assessment. And we will reasonably satisfy the customers to be intentionally homeless at the end of the relief duty. So the question is, at what point should a minded to letter be sent to the applicant? And if anyone, including Georgie, maybe wants to start on that.
Well, what I was going to say is I'm actually not sure the what would be too early and what the exact time of when the minded to letter should be sent. But I guess if you have it too early, then the local authority has very much showed their hand. And if there are specific things that they take issue with, especially relating to affordability, if they failed to particularize what they say your excessive expenses are, you can use that as an opportunity to say, well, you've not set it out in this minded to letter. We've since gathered this wealth of evidence that shows there isn't affordability. So I'd kind of use that to your advantage, but I'm not actually sure, and Ed might be able to assist when that minded to letter should be coming.
I don't really understand the situation. There's something to do. There's a complaint to the ombudsman, a lot, as well as I don't know the question. But I mean, obviously, the local authority in complicated affordability cases almost invariably serve a minded to letter, which sets out their assessment. So I mean, that's, yeah, it's usually, and then you get the actual review decision within a month or so. But obviously that should be at the point where the investigation's taking place and the issues, the nooks and crannies of the case have been looked into, in particular on affordability, where either the solicitors have put in detailed representations as to daily living necessities, etc., or there's been an interview and a record of that.
Okay, well, the next question that I've got up here, and this one is, I think, for Ed, if I can, or Ed first anyway. It's from Philippa Metcalf. And she asks as follows. Would a local authority be able to find an applicant intentionally homeless if they decided to voluntarily contact the local authority to close their case during either the relief duty or the main duty stage, and before they've received any accommodation offers? Because I'm talking now about the applicant, because they've changed their mind and now want to approach a different borough. So in essence, is that potentially going to get an intentional homelessness, and how would this affect their overall case? Thank you.
I mean, if it doesn't relate to them, an act or omission involving accommodation that they're in, losing that accommodation, then the short answer is no. But obviously, if they've, I mean, it depends which stage. I don't think, I mean, temporary accommodation, you can't be found intentionally homeless from it. But obviously, if you've already been provided accommodation under Section 193, then of course, if you then decide that, but you haven't been dealt with under Part 6, then you could have, obviously you could be found intentionally homeless if you give that up and apply to another authority. But if you're just at inquiry stage or the early stages, if it doesn't, I can't see that you're not entitled to close the file and go to another.
Yeah, so because I think that's really the question is, we're not talking about a situation where someone has given up a home they're actually living in.
Yeah.
But on the surface, they've given up a revenue, a means of redress, a kind of right, which could lead to housing.
No, but
so can that be enough to?
If it's just an application form filled in and no, there's nothing that prevents. I mean, this is one of the things that you can actually apply to more than one authority at the same time. But what will happen is that if you're accommodated by one authority, the other authority in temporary accommodation, the other authority say, well, you've gone with them, so we're not going to deal with you. So no, I don't think. I think you're entitled to, but obviously, in terms of if it involves giving up accommodation, yes, you'd be in danger of being found intentionally homeless. Yeah.
I was going to say, if we actually go back to the definition in Section 191 and all 6 of the stages that need to be met, as Ed said, this is going to fall down on causation, because if they weren't already in accommodation and they weren't giving that up, so if they were homeless when they approached the first authority, then there's going to be no link between them withdrawing their application and them not being in accommodation anymore. But it might change depending on if that on the stage that the local authority has progressed their application.
Fantastic. Right, the next question I'm going to give to Georgie in the first instance, and it goes like this. It's from an anonymous attendee who asks, how do we approach out of area offer of accommodation? The client has refused offer due to the distance and her mental health at the time. This is very detailed. It says she was pregnant. I mean, obviously, people should feel that you don't need to say specifically about clients. If we keep them quite general, I think that's ideal. But what's in the question is she was pregnant at the time and argued that moving out of area will lead to loss of her family support. Georgie, do you want to lead off on that?
Yeah. So from my understanding, failure to take up an offer of accommodation will not suffice to be found intentionally homeless, and that's the position echoed in the current homelessness guidance. I think I put it on the slide at paragraph 9.12. But of course, it will be fact specific. I'm just having a look at the slides again.
Well, perhaps while you're looking, Ed, do you want to just say anything briefly?
Yeah.
I mean, basically, if you're talking about if a duty's been accepted, right? So you've got a section 184 decision and it's section 193, and you refuse an offer of out of borough accommodation, then they'll discharge their duty. And then when you reapply, they'll find that you're intentionally homeless because you should have accepted it. There's a lot of case law and cases on the whole question of out of borough offers. There's a whole raft of cases, and there's a recent case, Norton, that's quite helpful to do the technicalities of making offers. But there's cases like Al Bikayat and Broderick, which are quite unhelpful to do with out of borough placement. So, I mean, the local authority has to follow all the guidance in making an out of borough placement offer, and they do need to take into account family support, etc., as part of their assessment. So it's certainly, we've a lot of cases where there's substantive challenges on review and section 204 appeals to do with out of borough placements, and a failure to investigate and assess the actual needs. But you do need to get really good evidence. My experience is, if you just say, I live in this locality, I have lots and lots of family support, I can't do without them, that won't wash. You have to specify what support's being provided, why you need the support, if there's any medical evidence in support.
Yeah, I think what I was getting at is that they won't be found to have, they won't be intentionally homeless from the accommodation that they refused because they never occupied it. Yeah. So the question is, did the refusal lead to the loss of the temporary accommodation, and did the refusal then lead to the discharge of the duty with no duties being owed at that point? So for their present application, there might be other factors that cause the loss of the temporary accommodation, although it will be a consideration for applications after all the duties are discharged.
Fantastic, thanks both. Now listen, I'm going to take a few more questions, but I'm conscious that actually right now questions are coming in faster than the panel are able to answer them. So that may well mean that by the end of them, I'm just going to have to stop. I'm going to stop at 12:30. It may be that some questions don't get answered. And if so, my apologies. I'm literally just taking them in the sequence that they came in now.
Well, if people give details, but I'm sure Georgie's happy to answer them directly. I would as well.
It's always good to volunteer someone else, Ed.
No, I do as well. So,
Thank you. Let me see, because we do have a few more. Right, so this one goes as follows, and it's an anonymous one, but I think the situation which we get quite a lot. Perhaps if I take this to Ed first, are there any specific arguments which can be raised where the deliberate act is a long time ago, but there's been no settled accommodation to break the causation? I have a case where deliberate act was 7.5 years ago, but council is still relying on it.
I mean, that's one of the I mean, that's been raised in a number of the cases on causation, and it said if you take it to an extreme, someone who left home when they were 17 and they're 65, you know, are you still going to find they're intentionally homeless because they left their parents' home? So I think the longer it goes on, the more it's difficult for the local authority to justify that approach. But it's very fact specific. You'd have to look at where they've been, et cetera, et cetera. But I think 7.5 years sounds quite a long time to be, you know, it's the mark of Cain. You don't carry it around. And there is, I'm pretty sure in Halle there's reference to it, and quite a few other Court of Appeal decisions as to that. It's got to be a fair assessment, a fair exclusion, as it were, from the statutory protection. So yeah, I think you may be able to challenge it. It's quite interesting, yeah, because I don't recall any case where the Court of Appeal has actually looked at that in detail.
Thanks. Okay, so the next question that I've got now, and I'll give this to Georgie first, if that's all right, goes like this. It's from Clementine. It says, perpetrators of domestic abuse making homeless application are often found intentionally homeless, as it's their abusive behaviour that caused their homelessness. But considering the risk to the survivor, it wouldn't be reasonable for the perpetrator to still occupy the property. How can we get around intentionality so that they receive housing support?
Well, I think the traditional position is just that, what you've set out, that perpetrators of domestic violence who are excluded from their home will become intentionally homeless because of their action. I don't know if there is any. I completely take the point that it wouldn't be reasonable for them to continue to occupy, but I don't know if there's any specific authority on that point.
No, I think yeah. I mean,
perhaps before Ed answers, can I broaden this out a bit?
Yeah.
I'm asking this as a bit of a provocation, really. But would there be any point even trying to run, say, an indirect discrimination argument? You could look back and say, you know, how many times has the council taken intentional homelessness against people? And if actually the pattern is they've done this against 90 men and 2 women, isn't this indirect sex discrimination?
Well, it's a particularly unattractive argument.
Terrible argument.
I'd rather you run it than me, David.
I mean, as Georgie went into, the case law says that they're entitled to look at what is the actual cause, and it's very often look at the domino effect. So if you commit egregious acts of domestic violence, and the consequence, you may not foresee the consequence, but the consequence is that you get an ouster order is made, etc. I think it's extremely difficult to argue otherwise, to say that it's not something the local authority could look at. It would have to be an exceptional case.
Okay, I will move on then to the next question we've got here. And it's from Bianca Sadler. I can't remember who actually raised this. So if either of you come in. Yeah, so the question is, could you go back to what you said about a marriage breakdown being a break in causation?
Yeah, so I think I probably should have gone into the facts a bit more on that particular case, but I was trying to get through quite a lot, but now that I've got the question, I can take the point. So the case I cited, it was R and Basingstoke ex parte Bassett. So in that case, so they'd moved out of the family home and sold it. So they gave up secure accommodation and they went to stay with the husband's family, so the in-laws. But whilst they were staying there, and that was precarious accommodation, whilst they were staying there, their marriage broke down and the wife moved out, and she took the decision to move out. But it was found that the final homelessness hadn't related from the decision to give up their stable accommodation. It had resulted from the breakdown of their marriage whilst they were in the precarious accommodation of just living with the in-laws. So that was an intervening act that broke the chain of causation in those particular circumstances.
Yeah, I mean that the case. Funny enough, we relied on that a lot as an event not associated with settled accommodation, etc. But you look at what is the actual cause of the homelessness, And Bassett's really helpful case. It was criticised by the Court of Appeal in one case, but then it came back in Halle. They refer to it again, and they say, yeah, it's a proper approach to take. Another example of situations where, in terms of causation, you're not liable. So yeah, relationship breakdown. But again, it will depend on how, as Georgie says, you've got to go through the sequence of events.
Okay, so we're down to the last two questions now, and just a couple more minutes before the seminar ends. One question, again, happy with either of you answering this. It's from an anonymous attendee who asks, ceasing to occupy, can acquiescence be claimed if the accommodation has not in fact actually been lost? E.g., section 193, duty accommodation offered to initial applicant, then reoffered to remaining household member of section 188, continual occupants throughout.
I mean, that's a very technical. I mean, it would come down to whether or not there was a discharge of duty under section 193. I mean, you've got lots of cases on acquiescence between couples. So you look at whether or not it can be determined that you agreed or went along with the decision that was made. So if someone refused accommodation, if you let them make the decision, then it's acquiescence. You can be liable for the consequences of that. Well, I don't really understand, the factual situation.
Yeah, I think that might be one for someone to follow up with emails. And again, both Ed and Georgie said they're very happy to do that. So then we get to the last question of the evening, which is this. Oh, no, we have two more. So I'm going to ask them each in turn with the pause between them. Question one, for the last two questions even, question one reads, to follow that question, how about a family that have accepted accommodation out their area, but some 9 months on have not settled, kids not at school and want to return back to their own area where their family are? Would they be found intentionally homeless? They are 5 hours from home. So that's Lindsay asking about people returning back to their own area. And then the final question will be from an anonymous attendee. If an 18-year-old in care breaks the rules and is evicted from the semi-independent accommodation, can the local authority claim the young person has made herself intentionally homeless? So two questions there, and but answers to either, they'd be appreciated.
I mean, I think the one to do, if a family's accepted accommodation out of borough, now that's normally, it's going to be private rented accommodation with a 2-year contract. So if you've accepted it, unless there's fairly extreme circumstances, if you give that up, you're in trouble. There was a case last year called Chalmers and Nottingham, where permission was granted to go to the Court of Appeal. It's Gordon Court North case. And I meant to check what happened because I can't find it. It's meant to be listed in the Court of Appeal. But in that case, accommodation was accepted, but then there was huge problems to do with mental health issues and lack of family support. So the accommodation was given up. They found intentionally homeless, and Equality Act issues were raised, and they got permission to appeal. But generally speaking, if you give up that type of accommodation, they're going to say that was accommodation that falls within section 191. You've made yourself intentionally homeless. Now, then you'd have to show that it's not a deliberate act, etc., or it was not reasonable for you to continue to occupy. I think it'd be quite difficult to argue section 1912, but those would have to be the arguments brought to bear.
Fantastic. So Georgie, can I take you the only unanswered question we have left, which is this one about the young person?
About the care leavers. Yes. So there's in the Homeless Code of Guidance, both in chapter 9 and in chapter 22, there are specific provisions that the local authority has to cooperate with the relevant children's services and make inquiries to understand the young person's emotional and mental well-being, maturity, and general ability to understand the impact of their actions. So that evidence should really help demonstrate that it's not a deliberate act, that there is other things going on, and the fact that it's like in the code, local authorities with the assistance of children's services should be careful to make findings of intentional homelessness cases, especially when they're still in, if they're still in care, and even if they are care leavers thereafter.
Well, listen, that's the end of this session for tonight. Can I really now would be asking the audience to give mark their gratitude in the usual fashion, because I think in that last session we worked, both Ed and George, extremely hard, bombarding them with questions. And I hope that the answers were genuinely useful and going to be of value to the people who've been listening on the call when you go back to your own practice and work on these cases. Many thanks. As you heard from me at the start, we'll have plenty more seminar and events over the next few weeks, including another housing event on the Renters Reform Bill on the 18th of July. Please do join us soon, and thank you very much. Bye then.
Thank you very much. Thanks, David.